Welcome back to the deep dive. Today, we're taking a shortcut straight into, well, maybe the trickiest part of negligence law, proximate cause. We're really zeroing in on that classic conflict. When does a defendant's mistake stop being the cause and become just a background condition that allowed something else, often something reckless, to actually cause the harm?
Exactly. And that distinction, cause versus condition, it's absolutely fundamental for civil liability. To really get a handle on it, we're going to use a key case from the Illinois Supreme Court, Abrams v. City of Chicago. And we won't just look at the outcome. We'll model a nested element-by-element legal analysis. We have to see how the law separates that simple but-for link, cause and fact, from legal cause, which is really all about policy and, well, predictability. Then we'll build that into a framework for you.
Okay, sounds good. But before we get into the really tragic facts of Abrams, let's just ground ourselves a bit. What are those basic building blocks, the four elements for a negligence claim, and where does causation fit in that picture?
Right. So, for any negligence claim, the plaintiff has to prove four things. First, that the defendant owed a legal duty. Second, the defendant breached that duty. Third, that breach was the proximate cause of the injury. And fourth, the plaintiff suffered actual damages. Proximate cause, that's the element we're digging into today, and it's tricky because it actually has two parts itself. You need both cause in fact and legal cause.
Ah, okay, so two hurdles right there within proximate cause. Can you quickly define those for us before we jump into the case?
Sure. Cause in fact is, well, it's the basic historical link. We usually use the but-for test, you ask. Would the injury have happened but for the defendant's negligent act? If not, you've got cause in fact. Pretty straightforward usually. Legal cause, though, that's the policy part. It sets the boundary for liability. It asks, essentially, was the injury foreseeable enough? Like, should we, as a matter of policy, actually hold this defendant responsible for this specific outcome?
Understood. And that foreseeability piece, that sounds like where the real battle often lies. Okay, let's analyze Abrams v. City of Chicago. First, what are the legally dispositive facts? Give us the core story here.
Yeah, the facts are, they're deeply tragic. You have the plaintiff, Patricia Abrams. She's in labor, contractions about 10 minutes apart. She doesn't have a car, so she calls 911 in Chicago, twice, actually. But the city dispatchers, they refused to send an ambulance. They were following these flip card rules that said contractions more than 5 minutes apart weren't priority I. So Abrams, understandably desperate, gets a friend, Henrietta Young, to drive her. On the way to the hospital, Young runs a red light, apparently honking, and crashes into another car. That car was driven by Gregory Jones. And Jones, well, he was going way too fast, like 75, 80 miles per hour, reportedly substance impaired and driving on a suspended license. Abrams and her baby, Georgia Sabrina White, both suffered fatal injuries in the crash.
Wow. Just a horrific chain of events. Okay, and what was the core legal issue that the Supreme Court of Illinois had to decide?
Right, the issue is precisely this. Was the city's initial failure, refusing to send the ambulance, was that the proximate cause, specifically the legal cause of the deaths? Especially given that the immediate cause was, well, the actions of two very reckless drivers breaking traffic laws.
Got it. So what rule of law did the court apply to figure this out? Can you state the full black-letter rule for proximate cause and maybe break down its elements for us?
Okay. The main rule is proximate cause requires proof of both, one, cause in fact, and two, legal cause. And the test for legal cause hinges on foreseeability. The core question is, was the injury the type of harm that a reasonable person would see as a likely result or maybe a reasonably anticipated consequence of their own negligent conduct?
Thank you. Okay, now for the court's elemental analysis. Let's walk through this element by element, step by step. How did the court handle the first element, cause and fact?
Well, that part was relatively straightforward. The court pretty much conceded cause and fact. The logic is simple. But for the city refusing the ambulance, Mrs. Abrams wouldn't have needed her friend to drive her. She wouldn't have been in that car with Young, and therefore wouldn't have been in that specific collision with Jones. So yes, the city's refusal was a necessary link in the chain. Cause and fact was established.
Understood. Okay, so that brings us to the really critical part. What about the second element, legal cause, the foreseeability piece? This is where the whole case turns, right? Especially since an appeals court initially sided against the city.
Exactly. This is the make or break element. And the Supreme Court found that the harm was not legally foreseeable. Now, the question isn't just, was some danger foreseeable? It's much more specific. Was this kind of injury, a fatal crash caused by two separate drivers, both willfully breaking major traffic laws, was that a likely result of denying an ambulance when contractions were 10 minutes apart? The court ultimately said no. It was just too remote, too abnormal, to count as legally foreseeable.
Wait, I have to push back on that a little. If the city's policy basically forced a woman in active labor into finding emergency private transport, isn't it kind of foreseeable that the driver might take more risks? Speed a little, maybe push a yellow light turning red, trying to save the mother and baby. Why didn't the court see that increased risk?
That's a really sharp question. It gets right to the heart of tort policy decisions.
Hmm.
The court made a distinction. They acknowledged the situation wasn't ideal, but they pointed out that, well, millions of women get to the hospital safely using private transport every year. So the city's refusal, in the court's view, just put Abrams in the same position as, any other private traveler needing to get somewhere. And here's the key policy point. The law is generally very hesitant to hold someone liable for the later, independent, willful, and especially illegal acts of a third party. That tends to break the chain.
Okay, so these subsequent illegal acts are key. The court used prior cases to back this up, right? How did that case, First Springfield Bank and Trust v. Gallman, support the city's argument about foreseeability here?
Ah, yes, Gallman was crucial. In that case, you had a defendant who illegally parked a big truck. And everyone agreeing that parking illegally was a cause, in fact, of a pedestrian's death later on. But the pedestrian was killed while jaywalking across the street. The Gallman court said, look, the illegal parking didn't cause the pedestrian to decide to break the law by jaywalking. And the driver couldn't reasonably anticipate jaywalking as a likely consequence of parking badly. So the rule that came out of Gallman is basically that an intervening, independent, illegal act like the jaywalking usually acts as a superseding cause. It cuts off the original defendant's liability.
Right, so if the first negligent act didn't somehow encourage or make the later illegal act almost inevitable, the chain's broken.
How did the court apply that Gallman idea back to Abrams and the actions of the two drivers, Young and Jones? They applied it directly. The city's refusal to send an ambulance was seen as legally separate or remote from the independent illegal acts of Young running the red light and Jones speeding while impaired. The court explicitly said the legal causes of this tragedy were those two drivers willfully violating traffic laws. Those actions, highly abnormal, independent, and illegal, were deemed superseding causes. This means the city wasn't legally required to foresee that its refusal would somehow result in two separate, almost criminal driving acts happening later on.
The court also had to explain why the situation was different from other cases where a city was found liable because it actively created a dangerous situation. You mentioned cases like Lococo with confusing signs or Beale with a broken streetlight. What made Abrams fundamentally different?
Yeah, that's an important distinction. It really comes down to control and whether the city actively created the hazard at the location of the injury. In Lococo and Beale, the cities either made the physical environment confusing for drivers, like with bad signs, or allowed a physical danger, like a dark crosswalk, to exist right there at the scene. They made it harder for even a careful person to avoid an accident at that spot. In Abrams, the city's refusal didn't change the intersection miles away. It merely furnished a condition, the need for Abrams to find private transport. The city didn't control that intersection, didn't make the red light harder to see, didn't contribute to Jones's impairment. Their negligence was passive in relation to the crash itself. The driver's negligence was active, immediate, and illegal.
I think I'm seeing it now. The city's error created the opportunity for the drivers to be in that situation, but it didn't make the driving itself more dangerous at that specific moment. Okay, so after analyzing all these elements, looking at cause and fact, legal cause foreseeability, the intervening acts, and applying precedents like Gallman, what was the court's final conclusion in Abrams v. City of Chicago?
So in the end, the Illinois Supreme Court concluded, as a matter of law, that the city's refusal to send the ambulance was not a proximate cause of the fatal accident. They overturned the appellate court's decision. They basically said the injuries weren't the type of harm that was sufficiently foreseeable from the initial refusal to meet the legal cause requirement. The real legal blame lay with the superseding illegal acts of drivers Young and Jones.
Okay, let's try to really solidify this furnishing a condition versus legal cause idea. Maybe with a more visceral hypothetical for the listeners. Let's say a city dispatcher negligently fails to send an ambulance for someone with really bad acute food poisoning. Just awful. The sick person's neighbor sees how bad it is, tries to be a hero, and attempts to drive them to the hospital. But on the way, the neighbor crashes head-on into a stopped train. Why? Because the neighbor was completely distracted texting while driving and just swerved uncontrollably off the road. Okay, was the dispatcher's original failure to send the ambulance the legal cause of those train crash injuries?
No, absolutely not. The dispatcher's failure clearly, furnished the condition, right? It created the need for the neighbor to step in and drive. That's cause, in fact, maybe. But the dispatcher's failure did not, in any way, cause or make foreseeable the neighbor's independent, unpredictable, and frankly, illegal act of texting while driving so badly they hit a train. That distracted driving, that's the superseding cause. It's highly abnormal, independently dangerous conduct. It breaks the causal chain just like the reckless driving did in Abrams. The city isn't expected to anticipate that kind of extreme, subsequent illegal behavior.
That really drives the point home. That distinction has got to stick with you, the listener. It highlights how but-for cause can be almost irrelevant if the actual harm hinges on some later unforeseeable criminal or just wildly reckless act.
Exactly. And, understanding this is key because it reflects a core policy in the law. Liability has limits, generally drawn to foreseeable risks. We don't want to make, say, municipalities liable forever down the chain for every single bad, willful decision made by unrelated people that happens after some initial mistake.
Right. So, bringing this all together, what does this mean for you, the listener, when you face a complex causation problem, maybe on an exam? If you have an injury that unfolds through a sequence of events like in Abrams, how should you structure your analysis to avoid falling into the trap the appellate court initially did?
Okay, yeah, let's synthesize this into a practical checklist. Based on our deep dive into Abrams and Gallman, here's a step-by-step way to tackle proximate cause. Step 1. Cause, in fact, but for test. Always start here. It's the baseline. Ask, would the injury have occurred without the defendant's act? If the answer is yes, it still would have happened, then the defendant is likely off the hook right there. If no, you proceed. Step 2. Legal cause. Foreseeability test. This is the big one. Ask, was the injury the specific type of harm that a reasonable person would see as a likely or probable result of the defendant's conduct? Be specific about the type of harm. If it seems really remote, bizarre, or relies heavily on later illegal acts, raise a red flag and move to Step 3. Step 3. Analyze intervening acts. If some third party's actions contributed, you have to categorize that act. Was it foreseeable or unforeseeable? Foreseeable intervening acts usually don't break the chain. Think, like normal medical negligence in treating the original injury. That's often considered foreseeable. But unforeseeable intervening acts, what we call superseding causes, these do break the chain. And this is especially true when they involve illegal conduct, criminal acts, or seriously reckless behavior, like the high-speed impaired driving or running the red light in Abrams. Step 4. Condition versus cause. This is the final diagnostic test, pulling it all together. Ask, did the defendant's initial act actively create a hazard at the scene, like the bad signage in Lococo? Or did the defendant's act merely provide the setting or opportunity for an independent, illegal, or unforeseeable act by someone else to cause the harm? Like the city's refusal just created the need for private transport in Abrams. If the defendant only furnished a condition, then that independent superseding act is probably the sole proximate cause, and the original defendant's liability chain is broken.
Okay, let's just quickly recap that core idea one last time. The big takeaway here is that even if a defendant's negligence was absolutely necessary for the injury to happen, even if cause, in fact, is clearly met, they might still escape liability. The chain gets severed if the actual harm ultimately depends on unforeseeable independent criminal acts or really reckless behavior by somebody else down the line. It's like the difference between setting the stage and actually writing the dangerous lines the actors speak.
Precisely. You have to be able to explain that policy. My initial mistake, well, maybe a but-for cause, wasn't powerful enough, legally speaking, to override the responsibility that comes with the later willful, reckless choice made by an independent person.
Okay, so here's a final thought to leave you with, something maybe a bit more nuanced. The Illinois Supreme Court in Abrams sort of sidestepped the duty and breach questions. They assumed them just to get to the proximate cause analysis. But remember that detail about the dispatcher's flip card policy? Apparently it included the instruction, when in doubt, send.
Yeah.
Now, could that specific internal directive have been enough to establish a concrete legal duty that the city definitely breached? Would the court have been forced to confront that directly if they hadn't resolved the case on causation? That's something for you to mull over.